Confidentiality, Anitra Bular, Los Angeles Pacific University, Psych 475. What is confidentiality? Confidentiality is the ethical responsibility as well as the legal and professional duty to safeguard clients from unauthorized disclosures of information given in the therapeutic relationship. Professionals must not disclose information except when authorized by law or the client to do so. Because confidential rights belong to the client, the counselor may legally and ethically reveal a client's confidences once the client waives his right. There are, however, limitations to the agreement of confidentiality. For example, in circumstances where the counselor has the duty to warn and to protect, confidences must be broken. Important terms related to confidentiality are privacy and privilege. The client's private information has the right to be protected from visibility, access, and intrusion by others. The counselors must take care to safeguard private information in areas where there is more potential to unintentionally invade a client's privacy. Examples of such situations are employers' access to an applicant's or an employee's psychological tests, a third party's access to medical records, or a parent's access to their child's school and health records. Also to be considered is the possibility of a chance meeting or a scheduled meeting outside of the professional setting. If a counselor meets a client in public, revealing their relationship to the client would be an invasion of privacy as well as a breach of confidentiality. Privileged communication is a legal concept that generally bars the disclosure of confidential communication made to a psychotherapist from any judicial proceedings or court of law. Privileged information ensures that a client's personal and sensitive information will be protected from exposure by counselor in legal proceedings. This, too, is a right belonging to the client. If the client waives this right, the counselor is then obligated to disclose only the information which is necessary to specific individuals or agencies which are stated by the client. These three concepts contain guidelines helpful for adhering to the ethical codes for conduct when facing an ethical dilemma. Mary Alice Fisher, a psychologist and the founding director of the Center of Ethical Practices, designed a six-step ethical practice model for protecting confidentiality rights, which address legal mandates in an ethical context. First one is preparation. In order to thoroughly cover limits to confidentiality, it is important to have knowledge of legal limitations as well as any personal moral principles which may be relevant. After clarifying these limitations, the counselor should then devise an informed consent reflecting his ethical position as well as confidentiality limits. It is also a good idea to go over the document with the client to make certain they understand the items and to address any areas of concern. The second one is tell clients the truth. Again, in this step, it guides the counselor to obtain the client's consent and acceptance to confidentiality limitations, as well as giving an explanation of the professional relationship dynamics which may affect the client's disclosed confidences. Thirdly was to obtain truly informed consent before disclosing voluntarily. Only disclose information when it is legally unavoidable. And before doing so, make sure to get a signed document of consent from the client. So if there's a signed consent that when in intake where the client has already agreed to these terms, 6 months later when something actually legal thing actually comes up, then it would be wise to have them sign again, stating that they're waiving their rights or that they agree with disclosure. Okay, respond ethically to Legal demands for information. The counselor is to notify the client of pending legal demands for disclosure of privileged information. Thereafter, minimizing disclosed confidential information as much as legally possible. So when you do give out the information, just giving out only the information that's required and not giving anything additional, and making sure that you're applying to the law. Avoid preventable breaches of confidentiality. This involves a number of things: avoiding making unethical exceptions to confidentiality rule, establishing and maintaining policies directed at protecting the client's confidentiality, monitoring, note-taking, and record-keeping practices, avoiding dual roles that will create conflicts of interest in the courtroom, anticipating legal demands and the response to the requirements, encouraging clients to use protective measures on their own behalf, and not confusing laws that permit disclosures with laws that require disclosure. For example, disclosure of privileged information is permitted when a counselor is working under supervision. However, disclosure is required when legally mandated, when a client poses a threat to themselves or others. Lastly, talk about confidentiality. Talk about confidentiality, exhibit the ethical behavior, make sure to educate clients, students, supervisors about confidentiality as needed. As mentioned before, there are limitations to the confidentiality rule. It is the responsibility of the counselor to make clear any ethical or legal restrictions on confidentiality. Whatever those limitations, they should be listed on the informed consent document and gone over verbally with the client, clarifying each point as necessary. As previously mentioned, there are permitted disclosures as well as required disclosures. Some permissible disclosure requirements include situations when clerical assistants handle the confidential information, like office manager, or when the counselor consults with experts or peers for advice, when the counselor is working under supervision, so like a counselor in training, and when the client requests a release of information to like perhaps their doctor or to an attorney. Required disclosure would be a situation when clients pose a threat or a danger to themselves or others, or when the client discloses intent to commit a crime. Statutes involving child abuse or neglect or elder abuse, and information ordered by a court of law. HIPAA, the Health Insurance and Portability and Accountability Act of 1996 is a federal law that contains detailed provisions regarding client privacy, informed consent, and transfer of records. HIPAA regulations require those who are under HIPAA to provide their prospective clients with a clearly written information of how their healthcare information is used, disclosed, and stored. HIPAA privacy rule was designed to provide uniform level of privacy and security at a federal level. It was developed out of concern that information transferred electronically would lead to widespread gaps in client confidentiality. It requires technical, administrative, and physical safeguards to protect the security of health information in electronic form. So there are 4 standards for the HIPAA Act, which are privacy requirements, electronic transactions, security requirements, and national identifier requirements. For the privacy requirements, It requires practitioners to take reasonable precautions in safeguarding patient information, limiting the disclosure of protected information, payment management, psychotherapy notes, and a client's medical records and treatment activities. Electronic transactions requires HIPAA's goal here is to create a universal language for electronic communication so that healthcare providers can communicate with one another in a common language. Security requirements. Minimal requirements are defined in HIPAA, which are designed to safeguard confidential information and prevent unauthorized access to health information. Lastly, the national identifier requirement. Healthcare providers and health plans are required to have national identification numbers that identify them when they are conducting standard transactions. Only mental health providers within the covered entity of HIPAA are subject to these requirements. Those who are not covered are not required to comply but may choose to do so. Duty to warn and to protect. Duty to warn and to protect applies to those circumstances where a case and statute requires a mental health professional to make a reasonable effort to contact the identified victim of a client's serious threat of harm or to notify law enforcement of the threat. Duty to protect applies to situations in which the mental health professional has a legal obligation to protect an identified third party who is being threatened. In these cases, the individual usually has other options in addition to warning the person of harm. Counselors may be held liable of responsibility to protect the public from dangerous acts. Violent clients is neglected. There are a number of landmark cases which contributed greatly to the case laws set in place in respective states governing the duty to warn and to protect. Spearheading these laws is the Tarasoff case, which resulted in the duty to warn of harm to self and others, as well as the duty to protect. This after Tarasoff was killed having no warning that her life was in danger, even though the authorities were warned that she was in potential harm. Thereafter, the Bradley case resulted in the duty to negligently, that's a good word, release a dangerous client after a client whom was released from a mental hospital committed murder soon after. The third legal ruling was in the Jablonski case, and that was duty to commit a dangerous individual. So when a client was not involuntarily committed after the failure to obtain his prior records, which led again to another murder victim. The fourth legal ruling was in the Hetland case. The ruling extended the duty to warn to anyone who might be near the intended victim or who might also be in danger. So it extended the coverage from not just the third party who might be harmed, but anyone close to them. In this case, this was after the victim's child was placed in harm's way. So there are guidelines for cases involving the duty to warn and protect. So some are know the relevant laws in your state. Inquire about a client's access to weapons, homicidal ideation, and intentions, including whether a specific victim is involved. Consider all appropriate steps to take and their consequences. Obtain prior medical and behavioral history. Know and follow the policies of your institution. In case of immediate threat by a client, do not hesitate to take actions to protect yourself. And document all actions taken and the rationale behind each decision. So being prepared for the eventuality of dangerous clients will give the counselor a better awareness of what to do in these type situations. Additionally, the counselor liability will be reduced by following these guidelines for a judicious course of action, demonstrating adherence to the standard of care expected of a mental health care professional. In conclusion, confidentiality in counseling requires that all client records as well as disclosed information be safeguarded and recorded with respect to the client's privacy. Staying within the guidelines for confidentiality along with its limitations can be tricky. Fisher's six-step ethical practice model was designed to help the counselor navigate the various ethical codes and mandates more easily and effectively. The HIPAA Act assists mental health professionals within its covered entity to maintain confidentiality when collecting, transferring, and storing privileged information about clients. Duty to warn and to protect laws have been created which place limitations on confidentiality in order to protect the public from dangerous clients. Legal precedences for these laws began with the Tarasov case, whose guidelines are still relevant today as mental health and violence are alleged to have a connection between them. The ethical codes and mandated laws which support the principle of confidentiality are of great consequence to the counselor-client relationship. Mental health professionals should know and adhere to them, making judgments that are within the parameter of acceptable practice. Duty to warn and to protect potential victims. Counselors must exercise the skill and care of a reasonable professional to identify clients who are likely to do physical harm to a third party, protect third parties from a client judged as potential to be dangerous, and treat those clients who are dangerous. Counselors faced with potentially dangerous clients should take specific steps to protect the public and to minimize their own liability. Examples of this would be keeping accurate notes of threats and other client statements, seeking several consultations with peers to gain advice, recording steps made to protect others. Most states permit or require counselors to breach confidentiality to warn and protect potential victims.